Thank you everyone for taking time off your lunch breaks to attend this workshop. The session is also being recorded for the benefit of those who are not able to attend today and will be made available online. I acknowledge that I am hosting this community education session from the lands of the Gadigal people of the Eora Nation. I also acknowledge the traditional custodians of the various lands on which you are all on today, and the First Nations people in attendance and who are watching this video series. I pay my respects to elders past, present, and emerging, and celebrate their ongoing cultures and connections to the lands and waters. By way of introduction, my name is Jason Teoh, and I am the Youth Solicitor at Marrickville Legal Centre. Through our duty lawyer service, I also frequently attend Burwood and Sutherland Local Court to assist self-represented individuals who have not received legal advice before going to court. Amy Dugan will be co-presenting this workshop. Amy is a law graduate at Colin Biggers and Paisley and is completing a secondment through our youth legal service. Amy has worked in civil litigation and insurance law. I would like to extend my thanks to Youth Action for being extremely supportive and collaborating with MLC to make this series of workshops for youth workers possible. Youth Action is the peak body that represents young people and the services that support young people across New South Wales. Quick disclaimer, while I am a lawyer, I am providing general legal information today, not legal advice. Often, the answer to most legal questions is, it depends. The reason for this is because the answer to a legal question often depends on a person's particular set of circumstances. If you or a young person that you're supporting have a legal issue, seek specific legal advice rather than rely on broad legal information. The workshop that we're presenting today is based on laws that apply in New South Wales as of May 2022. For those of you who are not familiar with Marrickville Legal Centre, we are a community legal centre that is based in Sydney's inner west. Community legal centres provide a free service to people who have legal issues but who are otherwise not eligible for legal aid. Through our statewide youth legal service, we can provide advice and assist young people in New South Wales with a range of legal issues. These include matters such as problems at home, disputes at work, owing a debt or having a debt owed to you, consumer disputes, discrimination complaints, tenancy, housing and strata disputes, fines, and criminal charges. In addition to legal supports, we also provide non-legal supports such as a domestic violence support service. We prioritize referrals from community organizations. If you are supporting a young person that requires legal assistance, please contact Marrickville Legal Centre via the inquiry form on our website. The objective of today's workshop is duty of care. I hope that by the end of the workshop, you have a better understanding of the three questions that we have on the screen, which is, first of all, what is duty of care? Who do I owe a duty of care to? What sort of standard of care is required so that you protect yourselves and you protect your clients? And also, what happens if you fail to provide the required level of care. What is duty of care? This refers to the legal obligation to take reasonable steps to protect others from the risk of harm that could be caused by your conduct. The law of negligence requires a youth worker to constantly assess the situation. This would allow you to identify risks that are reasonably foreseeable and to act appropriately by taking reasonable steps to reduce those risks. Youth work can be challenging because the standard of care that is owed to children and young people is generally higher than that of adults. You should recognize that you do not have an absolute duty to prevent all possible harm. Youth workers are not required to bubble wrap everything to protect the young person from all risks. For example, if you manage a youth refuge, there is bound to be conflict between clients. The risk of conflicts are reasonably foreseeable. While you may not be able to prevent a young person from becoming angry and harming themselves or others, the duty of care is fulfilled by providing adequate training and supervision, such as by having trained staff at the agency who are competent and able to handle situations like these.
Organisation owes a duty of care to its staff to provide, as far as reasonably practicable, a safe work environment, the necessary information and instruction, training and supervision for all of their staff members. If this is not provided, then your agency may be held responsible for breaching the duty of care owed to its members of staff. As a youth worker, you owe a duty of care towards your clients. Your primary responsibilities are to maintain confidentiality and privacy. You must also take reasonable care to minimise foreseeable injury to a client while they are on agency premises or at an activity organised by your agency. You also have a duty to act professionally, so it is important to act according to your level of expertise and your competence. You may also have a responsibility to the wider community where people are directly affected by you and by your work. For example, if your clients are IV drug users, you have a duty to ensure that no needles are left lying around the agency premises or outside the premises where other people may come into contact with them. You also have a duty to ensure that needles are disposed of appropriately and that staff are trained in how to dispose of the needles safely. Or say you drive clients, then you have a duty of care to take reasonable care to prevent collisions and to prevent damage and injury to other road users while you're driving those clients. When a young person hangs around outside your building, you have a limited duty of care. However, you should make sure your premises and the surrounds of your premises are safe. So, example, making sure that there are steps and paths and equipment and that those areas are kept safe. You should also communicate and enforce expectations about the behaviour on your premises to those who use it. If you're aware of any risky behaviour that is occurring, you should respond to it accordingly and try to ensure that someone does not get hurt. Outside of the physical boundary of your premises, your duty is minimised though. The extent of your duty will depend on the circumstances of each case. Often there is a duty of care, but the key question is what is required of you in order to discharge that duty. Every person, regardless of their nationality or ability, is owed a duty of care.
Like I said before, the key concept in duty of care type issues is reasonableness. The trouble is the law does not provide a black and white answer or subjectively clear answer of what is required to discharge your duty. Every circumstances needs to be assessed based on that set of on its own case. The amount of care required would depend on those circumstances, and that would require that a person acts reasonably in their dealings with someone to whom they owe a duty of care to. When the court determines what sort of standard of care is required, they often use what's called a reasonable person's test. What the reasonable person's test is considering what a reasonable person acting in your position would have done. Would they have foreseen the risk? What would they have done in response? Often you'll find that the test of what is reasonable involves competing responsibilities that needs to be balanced. And so you really have to assess the situation as a whole. However, I think you could, in a way, figure out what sort of standard is required by taking into account a number of factors, such as your experience, your training, your qualifications. So for example, someone who is a team leader, the standard required is probably higher than that of a new employee. Things like the relationship between the young person and the youth worker can also be taken into account. What I'm referring to is things like how well you know the young person. The better you know the young person, the law is probably going to infer that you'll be in a far better position to see risks and to be able to take those necessary steps. Another thing that can be considered is the age and capacity of the individual client. So where the young person has additional needs, the standard of care, like I said before, can be higher. The younger they are, and if they're the more vulnerable they are, the standard of care can also be higher. And so this is something to keep in mind when you are supporting someone with disabilities or health issues. In assessing what is reasonable, the courts would often have regard for what your agency policies and procedures are. If there are policies in place, then following those procedures would generally provide you with some degree of protection. But also the courts are looking at whether the policies adequately addresses those reasonably foreseeable risks. So often you'll find that policies would have requirements in terms of minimum staff numbers, in terms of first aid training. Where those policies are appropriate, they turn their mind to those risks. They sort of help by guiding you decide what sort of standard is required. One of the biggest factors there is the budget and resources that is involved in addressing the risk. The courts may approach it by asking this question: would it have been impractical for a person to reduce the risk? So if it's going to cost a lot of money, ridiculous amount of money or resources to address the risk, then perhaps that is not required, because a person is only required to take reasonable care. I think the takeaway from this slide is, if you are at any stage unsure about whether you have the duty or what you should do, the best way is to approach a colleague or get legal advice, because I'm sure your colleagues are reasonable persons, and that's something that the courts will consider, what a reasonable person in the same position would have done. All right, so next slide here is in relation to volunteers, students, and untrained staff. I want you to think about whether you think that volunteers and untrained staff owe a duty of care to clients. How many of you think the answer is yes? If you could put it, there is that reactions button. If you can put your hands up or a thumbs up, if you agree with it, if you think that a duty of care is owed by volunteers and untrained staff. Yep. I see a number of yeses. Yep. Very good. So volunteers and unpaid staff, they do also owe clients a duty of care, but it's important to keep in mind that the standard of care required may not be the same as paid and trained staff. However, volunteers and untrained staff still need to be informed about duty of care type issues, and they should be able to perform and carry out their duties in a safe manner. It is also important that all unpaid staff, students and volunteers are also trained in your agency's work health and safety procedures. Where the paid staff member is working with a volunteer or a student, a duty of care can coexist between both the volunteer and paid staff member. That said, the standard of care between both can be a bit different in that more is generally expected from a paid staff member. To minimize risks, a good idea is to avoid placing volunteers or untrained staff in a situation where they are left unsupervised, such as driving clients or running groups by themselves. This allows the paid staff member to step in case the volunteer is in need of assistance. In any case, volunteers should be covered by volunteer insurance or your agency's general insurance policy. Students who are on a placement may also be covered by their school or tertiary institution's insurance. If you are a volunteer, you should check that you are covered and that necessary insurance arrangements are in place before going on a placement. Likewise, the same type of due diligence should be performed by the agency prior to any placements.
So young people are bound to take risks, we know that, or to engage in risky behaviour. The law does not require you to predict and to prevent every situation that might happen. So remember, you do not have an absolute duty to prevent all risks. Your duty is to take whatever steps you can to minimise how frequently this behaviour occurs and the risk of injury as a result of that behaviour. The courts recognise that when people knowingly put themselves at risk, the duty of care to those around them is reduced. However, given you may be working with some very vulnerable people and at risk, people who are at risk, young people who are at risk, it is reasonable to expect that you and your agency have in place policies and procedures to minimise that risk of harm that they could cause to themselves. Obvious risks are dangers in circumstances would have been obvious to a reasonable person in that position of the person. The law says that you don't have a proactive duty to warn of obvious risks. Yeah, so if you breach your duty of care, this could lead to your employer taking disciplinary action against you. The person that was injured could also commence negligence proceedings. Negligence is a legal term and it describes a situation where someone fails to exercise reasonable care and this results in an unintended injury to another person. Negligence may be caused either by an action or by a failure to act. If you owe a duty of care and you breach this duty and you or your agency may be sued for negligence. In order to prove negligence, the person suing must prove, number one, that the worker or organisation did owe a duty of care, number two, that the risks were reasonably foreseeable, and number three, that the worker did something that a reasonable person would not have done in a particular situation, or that they failed to act in a reasonable manner. And number four, that harm was suffered by the person because of the unreasonable action of the worker. Harm can also include personal injuries and illnesses, emotional harm, loss of income, or damage to property. Finally, number five, they have to prove that the damage or injury was directly caused or contributed by the breach of the duty of care. And it's important to remember that if there's no injury, then they can't bring a claim for negligence. If an accident occurs while in the course of employment, the employer could also be vicariously liable for any negligence. What this means is that both you and the agency could be held responsible. If a person is injured, they are more likely to sue the agency, as the agency generally has insurance policies that will cover any compensation payoff. However, individual workers may also be sued. Often proceedings are brought against both the workers and the organisation. The agency may cover your costs and expenses if you are sued, but you should check your agency's policies to see whether they will indemnify you against the liability. In certain circumstances where you act in a private capacity, for example, if you choose to meet the client after hours without your agency knowing, then you may be held liable for any negligence against you that arises. So what should you do if you are sued? If you are named as a defendant, as in you were named as the person being sued, you should definitely talk to your supervisor and obtain legal advice. Your employer may provide a lawyer on your behalf, but you should also consider separate legal representation in the case that there is a conflict between the case being argued by you and your employer.
All right, so if you are off duty or not at work, I want you to think about what happens if a stranger is in need. There is no duty to rescue or assist a stranger that is in need. And the reason for that is that you don't owe a duty of care to everyone. You only owe a duty of care to people who are under your care. And so if there is no duty of care, you may not be legally required to do anything about it. However, I think it's a good idea to still call the police, ambulance, or provide first aid if someone is hurt or injured. If you choose to help this stranger, they could well come under your care. What that means is if you do the wrong thing, you could be sued for negligence. However, if you are voluntarily assisting a person who is apparently injured or at risk of being injured, and you're responding in a way that is in good faith, then you could have some protection because of Good Samaritan laws that exist in New South Wales. Right, so we'll run through a case study now. There'll be some questions after that, and I'll get you to give you a couple of minutes to think about the questions. But the case study is as follows. Let's assume for now that you were running a holiday program. The parents have provided a consent form. The consent form clearly says that the program finishes at 6 p.m. And everyone has been picked up except for Joe. Joe is 16. You've tried calling Joe's parents, but there's no answer. The policies and procedures of your agency states that you cannot drive your clients home. So you've been waiting around. It's been quite some time, and after half an hour, Joe says that she will get the bus home. And you know that Joe normally takes the bus home after school, so you decide that it's okay for her to make her way home. You wait until Joe is on the bus. What I want you to think of, and I'll give you a couple of minutes to do so, is think about whether there is a duty of care to Joe. What are the reasonably foreseeable risks here? What is the standard of care expected? And a tip for that is you've got to consider all the circumstances. And lastly, think about whether if something does go wrong, does the conduct fall short of the standard expected? Is this person in trouble because they are negligent? Take 3 to 5 minutes to think about it, and then we'll discuss after that. Thanks, Donna. Let's get you all to discuss in that. Anyone has any ideas as to whether there is a duty of care? Anyone has any thoughts?
Yeah, this is the code we were saying. We've just discussed where we have young people that we have events, and when they're not available to be picked up, sometimes look, we don't have a bus service out here for starters.
Yeah.
So in our scenario, they may need to go 25 minutes one way, and kids might need 25 minutes the other way.
Yep.
At 9 o'clock at night. So we would say it would be a duty of care.
That makes sense. So I think the answer to the first question is, of course, if this youth worker is running the holiday program, they've accepted the young person in their care. So of course, a duty of care is owed to the young person. The question here is, I'm trying to identify what the reasonably foreseeable risks are and what's the standard required. Every youth worker in this situation would be thinking about what would then happen if something happens to Joe, the young person. What if Joe doesn't make it home safely? Whether the youth worker was negligent would depend on the standard of care that is required. This would mean taking into account the reasonableness of allowing Joe to go home by bus. But I think here in this situation, Joe's parents knew what the finishing time was. Joe is 16, she's not 10. She often travels by bus. You have tried to contact her parents repeatedly. Your policy and procedures clearly state that you can't drive clients home. You waited at the bus stop for Joe to board the bus. According, I think, in this set of circumstances, the conduct doesn't actually fall short of the standard expected, so that they're fine, they're not negligent. However, because consideration is taken of the conduct as a whole, I think it's not a bad idea on the side of caution to give Jo a ring later in the evening to just check on her to make sure that she's arrived home safely. I think that would be a good idea. It just provides you with an additional layer of protection. So in the circumstance that you discussed earlier on, Shane, I think there would be no duty of care types issues if a person has taken reasonable care and appears to be reasonable in your case. What is the effect of the signed consent form? So earlier on, we go back, taking you back to the second point there. What is the effect of the consent form that the parents have signed? A signed consent form, it protects you from a claim that you've taken a young person away without parental knowledge. What it does not protect a person is if their behavior was careless or if they failed to prevent a foreseeable risk that the parental consent was provided for, they can still be sued by negligence. So those consent forms, it protects you in some regard, but it doesn't completely protect someone, doesn't necessarily enable someone to be negligent. So this brings us towards the end of the workshop. We've got the 3 questions I started off with. The first question is, what is duty of care? Duty of care refers to the duty to take reasonable care to ensure that someone you're supporting is not harmed. That duty can also extend to people you're not supporting, but who may experience or who may be subject to foreseeable harm. The key word here is reasonable. This duty of care is not an absolute duty. It's merely there to recognize that a person should prevent or do what they can to reduce the risk of reasonably foreseeable harm. Who do I owe a duty of care to? A duty of care can be owed to someone who could be harmed as a result of a person's negligence. So think of clients, people that you're supporting. Think of co-workers that you're with. If you do the wrong thing, you left the floor wet, someone could potentially slip. But also members of the community who could be affected by a person's negligence. What happens if I fail to provide the required care? If you don't provide the required care, disciplinary action can be taken against the person by your employer. If there are injuries, chances are negligence proceedings can also be started in court against the youth worker and also the employer. Again, I want to reiterate that if you are unsure, and there are always going to be circumstances where it's unclear, a person you don't know which way to sort of go, it's always best to speak to a colleague or a manager, even better, or seek legal advice. Shane, yes, we will circulate a copy of the recording, so we will have the recording up eventually, and we can also send out other slides if that's what you want. I'll send that to Freya, and Freya can circulate that. This pretty much brings us towards the end of the workshop. I'm gonna pop a link into the chat. If you guys can all provide us with some feedback on what you enjoyed about the workshop, things that can be improved on, topics in the future that you'd like us to discuss, we really welcome any sort of feedback. We're so thankful to all of you for taking time off, presumably your lunch break, to attend this workshop. And I'm happy to take any questions as well.
Wonderful, thank you, Jason. Any questions? Would people like to take themselves off mute and have a little chat? Don't have permission to view the form.
Sorry, probably the form wasn't set up properly. My sincere apologies. I'll send the link to Freya, and Freya, could you circulate that as well?
I certainly can. This is why I got you all to register, so I knew who came. But Chris, thank you for letting us know. It's always good to know that information. So you got a couple of comments in there, Jason. It's great information. People enjoyed it.
I'm glad everyone found it useful. Of course, we're trying to run these workshops to educate youth workers and allow you to better support clients. But also, if you've got a young person that requires support, I want all of you to know that Marrickville Legal Centre, we are a statewide service. I know the name is Marrickville, but we assist any young person living in New South Wales.
And I must say, like, when I was a youth worker, I'd used Marrickville Legal Centre a few times with my clients, and they were always very helpful. And while we are jacks of all trade as youth workers, we don't have to know everything. We can always rely on help from others. Shane, did you have a question?
I do, yes. Shelley here.
Shelley,
thank you. So we have the youth drop-in service here in Kyogle. That's after school, young people come, and we also run a holiday program. Some of those events might run late, for example, into the evening. We might have young people coming to those that aren't regulars at drop-in. And it can be, I guess I wonder about the where our duty of care is, where those events are still drop-in, but some parents will drop their young people off, and I guess say that they'll be back in a couple of hours to pick them up, for example, but the nature of those events remains, I guess, drop-in, where there hasn't been that consent form, and a young person might leave the space where the disco is or the film night is, and wander off into the night in a small town. I'm curious around where that would all sit.
That's a very, very good question. So in relation to the consent form itself, that's not something that is required. Again, like I said, it doesn't necessarily protect someone from negligence. It just prevents a claim that a young person was taken away from the parents without consent. I understand the nature of drop-in sessions. And so perhaps if it depends on the age group as well, where the young person that you're supporting is older, where the parents are aware of the nature of the service, that it's a drop-in service, that people may leave early, they may wander, they may go off somewhere, then the duty of care, the standard of care required will not be the same as if it's a sort of more structured program where there is a set pick up and drop off and pick up time. So that's something to keep in mind. And I think the goal here is making clear from the start what the standards are, what the expectations are, and that provides you with some degree of protection. And also, I think if your agency has policies and procedures in place, that can also be very useful, because I know you never know when one day something goes horribly wrong and then you go, oh, should have thought about that earlier on. So policies and procedures are probably a good way to address some of your concerns.
Okay, thank you.
Thank you. Sanji, do you have a question?
Sanji, is that? Hi everyone. Thank you. Thanks, Raya. Okay. And thanks to Jason and Amy. Can you guys hear me? I don't have speaker. Okay, awesome. So I have a question that's related to the case that you just presented. I had a similar experience. It was for a youth camp. Coming back from youth camp, everyone was on the bus, and I was waiting with some young people for the parents to pick them up. And there was a young person who was in the younger youth age, like 12 years old, who was waiting, and she was showing me that she was talking to her mom, and her mom said she was going to pick her up before the camp started and then after the camp. And however, we waited half an hour later, and the mother suddenly just said, no, she can just walk home. And I actually decided to just drive her home in my car. And because she had a heavy luggage and it was raining, and but now that we started this today, I feel like that might not have been appropriate, even though I did ask my supervisors whether that was okay if I did that, and they said yes, it's okay. Well, what are your thoughts about that situation?
Yeah, it's a very good question, and these sort of scenarios come up, as I understand, from time to time. So where it's a 12-year-old person, they're much younger than Joe, who was 16. It's raining. The person has a luggage. Who knows what could have happened? The walk is like sort of could be a long walk home. Who knows what could have happened there? I think it's good that you've turned your mind to these issues. It's good that you're sort of concerned for the welfare of the young person. I think it's actually not a bad idea where your agency allows you to sort of drive the young person home, or even walk them home, because you've done whatever you can. The key concept here is try to think of take yourself out of the equation. Think of a reasonable person. What if a reasonable person, a youth worker as well, who was running the program, finds himself in the same exact situation? What would they have done? And I think that where it's a 12-year-old, where they've got heavy luggage, it's the weather conditions and all that, taking into account all the circumstances, I think reasonable care would have involved driving or accompanying the young person home. Everyone agrees with, I'm sure everyone here are reasonable persons as well. I'm sure many of you would probably have done the same thing.
Whew, okay, thank you. That's reassuring. Thanks for that.
And I think that just really highlights, Jason, that there's a fine line with some of the work that we do. And of course, we always should be guided by internal policies and procedures, and particularly legislation. But sometimes we need it's all good. Like, actually, the fact that you called your boss, I think, is incredible. So you had that extra person to ask that, not even permission, but just to kind of reflect, to think about it and go, what is the best course of action in this moment?
Okay, to confess, I actually told my boss after I did it. Now that I remember, yeah. So that would not have been good, because
No, that's okay, because sometimes we have to make those calls as a part of our practice, and that young person wasn't at harm, so that's good. Any final questions for Jason and Amy while we've got them on the line? Well, I must say thank you so much, Jason and Amy. So good to hear it all again. I know it's information that we can sometimes learn, but then it's easy to forget. Or just those little scenarios with just a little bit of differences. It's always good to be able to talk through those. So thank you so much. As mentioned at the start, we have recorded the session, so we will distribute that to you, as well as the PowerPoint slides and that feedback survey. Marrickville Legal Centre and Youth Action really keen to do more of these. We've got 2 more coming up, but even in the future, we'd love to do more. So your feedback is really important for us to be able to see what topics would be useful, but also how can we make sure that these sessions suit your needs the best. Jason, did you want to say any final words?
No, thank you everyone for attending the workshop.
Yeah, thank you.
Thank you so much, everyone. Well, have a good afternoon. I know it was on your lunch break, so I do hope some of you were eating while we were doing this. But have a lovely afternoon. And if you haven't signed up for the next 2, I'm going to add that into the follow-up email as well, so you can remember to register.
Take care, everyone. See ya.
Bye.